moved out rightfully when I was 2006. I had breaks in between,
Okay.
but all right.
Let's call the regular meetings of the Planning Commission study session for August 3rd, 2022 to order. Adam, would you call roll, please?
Commissioner Camp, he contacted me earlier. He will not be here for the study session, but he will be here for the regular meeting. Commissioner Cosgrove,
Here.
Commissioner Davis. Here. Commissioner McCacken contacted me earlier. He will not be present for the study session or the regular meeting. Commissioner Prescott.
Here.
And Vice Chair McCann.
Here.
And Chair Crandall.
Here. The item today is legal best practices, and Adam, would you introduce the representative for Best Best and Krieger?
Yes, we are joined today by Hung Down Nguyen of Best Best and Krieger, and she is filling in for our Assistant City Attorney Mal Richardson tonight.
Thank you.
Yes. We're going to put up a PowerPoint and Kate, if you would let us know, you'll be controlling the slides, correct?
Wonderful.
Before you start, just a heads up, the mics are always on.
Good point, Chair. All right. Good afternoon, everybody. Thank you for the introduction. Again, my name is Hung Down Nguyen. I'm a partner with the law firm of Best and Krieger, which serves as the city attorney for San Clemente. Next slide, please. I am happy to be presenting to you the Planning Commissioner training. I'm aware that we have a new commissioner. Welcome, Commissioner. And for the rest, this may be a repeat, so my apologies, but hopefully it's helpful to everybody. Next slide, please. So this is a mini public ethics presentation. The reason I say that it's a mini presentation is because every couple of years, the commissioners and other public officials take a longer version of this, which is called AB 1234, and it covers 2 hours. This won't cover that, but it'll have just kind of a dry run of what you'll hear in a longer presentation. We're going to cover open meeting laws, which is generally the Brown Act. Then we're going to go through the financial conflicts of interest, including the Political Reform Act and Government Code 1090, which relates to contracts, due process and fair hearing, as well as the Public Records Act. All right. Just a quick note behind these laws are the idea of transparency and that, commissioners and public officials are operating and transacting business on behalf of the public and not for themselves. And so that's kind of the broad policy behind these laws. Next slide, please. So the Brown Act, again, the policy is behind this one is open meetings. We want meetings and the business to be transacted in public and not behind closed doors where people can't weigh in. And we'll go through what a meeting is, but the general theme is there can be no discussion or action on an item of business on, for example, the CUP that you'll be considering tonight, as well as the master plan sign program, unless it's on the agenda. Agendas are posted 72 hours in advance of a regular meeting and maybe even longer. I think sometimes San Clemente posts even longer than that, or 24 hours in advance of a special meeting. This body doesn't have closed sessions, but the council can certainly go into closed session for certain items as statutorily prescribed, real property negotiations, litigation matters. That's so that our cards aren't shown in public and we're not at a disadvantage when we're negotiating those things. And there are remedies and penalties that I'll get into in a bit. Next slide, please. So let's go very basic. What is a meeting? A meeting here is when a quorum of this body, here we have 7 folks, right? So 4 out of the 7, hears, discusses, deliberates, or takes action on something within the city's subject matter jurisdiction. So again, I just want to emphasize that the quorum could be hearing, discussing, or deliberating, not necessarily taking any action on an item, but simply having 4 commissioners getting together and discussing a matter of public business could violate the Brown Act. And what is, an item within the city's subject matter jurisdiction? Certainly, if an item is going to go on the agenda or has been on the agenda, an item on the city's budget, those type of things would be in the city's subject matter jurisdiction. And again, for a meeting to properly occur, it needs to be noticed. It needs to be agendized. I think when this all came about, when the Brown Act was actually passed, it was, backroom deals, the consensus would be made over a lunch meeting or a dinner meeting. There's case law out there that, there were some legislative bodies that the quorum of them would have dinner beforehand and then would have all the items be unanimous votes at the meeting. So those are the things that we look out for and we get worried about. Next slide, please. But there's also clearly not meetings that are statutorily listed in the Brown Act. The league conference is coming up, for example. I believe that the league also puts on a commissioner training. So to the extent that, a quorum of this body went to one of those league trainings, that would be perfectly fine. What would not be fine is, having lunch afterwards and talking about public business. Community meetings not organized by the local agency, a Chamber of Commerce meeting, for example, ceremonial or social occasions, ribbon cuttings and things of that nature, and meetings with other legislative bodies. Again, all these are fine as long as a quorum doesn't speak about public business during or before or after those gatherings. Next slide, please. So serial meetings, and we'll get into that a little bit more with depictions of that, is use of direct communication, personal intermediaries, technological devices, again, by a quorum of the legislative body to develop a collective concurrence to be taken on an item is prohibited. And so next slide, please. So here's what we're worried about that can quickly turn into Brown Act meetings is one commissioner either in person or calls that commissioner even via email or text message, says, hey, how are you voting on this item tonight? Or what do you think about this item? And then that next commissioner, pings another commissioner and says, hey, I've talked to this commissioner. We think that, we're going to go this way. Right. So that's that first depiction up there, A to B to C. The second depiction is kind of like a bike, a wheel and spoke type of depiction where you have an intermediary, channeling these type of communications to the various commissioners. I haven't had this situation, but but for example, developers and applicants can be out and about in the community and wanting to talk about their project, especially to commissioners, that's totally fine. And meeting with developers or applicants, that's on a one-on-one basis, that's fine as well. Or learning more about a project, driving by the location or the site, that's absolutely fine as well. But then, if a developer, applicant, or other interested party, right, ends up talking to 1, 2, 3 commissioners, 4 commissioners, right, and says, hey, all these commissioners are in favor of the project. What about you? And starts becoming an intermediary and having those conversations and being the kind of the middle spoke that's kind of channeling all this information, that becomes a problem that we do worry about. There's a carve out in the Brown Act that the kind of administrative person, the director that is assigned to the commission or the city manager when it comes to the council, can give information and provide, briefings, right, on various items. When I'm giving a briefing to my commissioners one-on-one, I'm very careful to say, here's the item that's going before you tonight. Can I answer any questions? But I'm very careful to not channel the communications I've had with other commissioners or council members and say, this is what this person is thinking. And I don't want to become that, intermediary accidentally, but certainly these briefings are fine. I'm just going to pause real quick for any questions. I know I've been going through a few slides, and if you have any questions, please feel free to chime in.
Go right ahead.
One thing, I have been on planning commission where they had a closed session
Oh,
before, so
great.
they can have them.
Yes, it's, thank you, Chair, Commissioners. It is unusual to have them, but yes, there's no prohibition on, planning commission having a closed session. Thank you for that point.
Yeah, we had a closed session mainly to meet with the attorneys. So we didn't put our foot in our mouth. And address things that are within our purview.
I think that's a great idea. And yes, to the extent Mal is very proactive, and he might do briefings one-on-one on two folks with him is fine as well. And certainly in a closed session would be appropriate.
And for quick thing, she was talking about the what can be discussed and all. Be careful not to ever say your mind is made up before the public meeting and before the public has the opportunity to present their information.
Absolutely. Yes. I have a few slides on due process, and that is a wonderful point that we'll go over as well. Thank you.
Now, you talked about developers, so where if two commissioners meet up with a developer and he wants to plead his case, that's fine, right? Even up to 3, but you really want to be careful there. I understand. Now, how do you deal with that spoke? Say the developers, the hub, how do any of us, I don't even want to get into it with the developer probably, but just driving by and seeing a project and the guy kind of has seen me before, flags me down and wants to speak or something. How do we know, he's the hub and talking to every single one of us, but none of us even know about it?
Right.
Maybe that's too deep, but
well, I think it's a very important point to bring up. And certainly there's nothing wrong with it, right? In complicated projects, it's actually even very helpful to understand the nuances of it. I've been on developer tours, right, of the project to just give a visioning of what is going to be built here and what the developer's vision is. So I don't want, and certainly the commissioners, we want the commissioners to continue to be steeped in the community, to understand the issues, and to seek that information, but certainly not to make up individual minds before all the information is presented in a public setting. If those meetings are had, one way we've done it in the past in some of my client cities is to have a staff member there to help guide that conversation, to kind of look out for those type of issues. Or certainly, at the beginning of a conversation, it could just be a friendly reminder. Hey, I don't want to know what you said other commissioners or what they have said to you. I'm mindful of the Brown Act, but I just want to understand more about this project. I just want information and not, to hear what other people have said. So I think there's ways to set that up and to do that responsibly.
Can I add to that?
Please.
Yeah, I would think that, if somebody's doing something that you're unknowing about, that's not on you. But if you call Karen and say, hey, Karen, I want to vote this way on this, I'll call Bart, and then you call Steve and Cameron or whatever, and, then you're kind of overtly violating this.
got it. Thank you.
Great questions. Thanks. Okay. All right, let's go on to the next slide. So this is a new law that came out. It became effective in 2021, AB 992. For a long time, the Brown Act didn't address social media and those discussions on social media. And so this is kind of a first of its kind. The legislative history behind AB 992 really addressed that the state was wanting public officials to reach out to their constituents on social media. There were some concerns on some public officials from around the state who said, I don't want to engage on social media because I don't want to accidentally engage in a Brown Act violation. And so this was to address that. So on one hand, through AB 992, there's explicit language that says, individual not council members, public officials can reach out to their constituents to give information about public business, and to solicit feedback and solicit information. And we are A-OK in blessing that. So that was very good. On the other hand, there are some prohibitions that you should be aware of. And again, it provides that a quorum of a legislative body can't discuss a matter of city business on social media. So again, that might look like, one of the commissioners puts up a post, or one of the commissioners responds on someone else's posts, and then 3 other chime in, and suddenly you have 4 commissioners who are discussing a matter of public business on social media. So that's not too different from what I've been talking about all along here. 4 commissioners couldn't get together for lunch or after this meeting or before this meeting to do that. So that's nothing really groundbreaking, but just kind of codifying here through AB 992. Where AB 992 gets a little bit different from what we've seen in the Brown Act is that it also prohibits direct responses from one public official to another if they both serve on the same legislative body, and if the issue is about city business. So let's say there's a vote tonight on one of the items. One of the commissioners is very excited about it, says, hey, this is what we did tonight. And another commissioner responds and comments on that, or simply even thumbs up it and with an emoji or whatever the emoji is. That is a prohibition under AB 992. So we're not just looking at a quorum now, we're looking at direct responses, which is a little bit different from what we've been talking about. So I'll just pause there, let that sink in, because that is a new law. Well, newer law.
So my question is, that apply all the time, or does it apply prior to the decision?
Good question. AB 992 doesn't distinguish the timeline of when, the matter was heard. It just says simply, these are the prohibitions on discussing items of city or local agency business on social media. It doesn't distinguish. So our interpretation, it is very new, and I'm not aware of any case law or any opinions that have been enlightening this new law, but the interpretation at this point would be at any time.
We've had projects come before us at different times that have not become a true application or anything. It's just a cursory presentation that they're fishing a little bit. Would that period of time be included, or only once it becomes truly city business?
Commissioners, that's a difficult question. It simply talks about city business. I would say that if it's been on an agenda or will be on an agenda, then that could be an item of city business. It's unclear, right, whether it will come back or not. And just taking a conservative approach, if we think that there's a possibility that it will come back, then that could be regarded as an item of city business. And again, there could be a view that takes an opposing approach. It's just simply the statute isn't that clear in the definitions of what that means. And so just a conservative approach is, if it could be an item of city business, then be aware of these prohibitions. Okay, well, next slide, please. So continuing with the Brown Act, so you have regular and special meetings. Again, special meetings only need 24 hours notice. All of your meetings will have a public forum. The unique thing about special meetings is, well, at a regular meeting, members of the public can come in and just, there's going to be a public comment period where they can talk about any item of city business, whether or not it's on the agenda. Special meeting public comment periods are only for items are on the agenda for the special meeting. In the public forum, commissioners, if it's not on the agenda, so somebody comes in and wants to talk about an item that's not on the agenda, again, we can't have a full discussion on that, or certainly not take action on it, right? Because it wasn't on the agenda, it wasn't noticed 24 or 72 hours in advance. And so the rules that are in the Brown Act is that the commission can refer to staff and say, can you bring this back, or can you answer this question briefly, or give just a quick bit of information on that, or respond briefly to the comment. Certainly after sitting with commissions and councils, there's a temptation to have a lengthy debate sometimes, or to have a fuller discussion on an item that might be a hot button item, but it's not on the agenda. But again, for the folks who didn't know that item was going to come up, and because it wasn't on the agenda, for their benefit, we don't want to get into full discussions on items that aren't on the agenda. A member of the public has the right to speak at a regular meeting on each and every agenda item, on items including the consent calendar, and it could be done before or during the commission's consideration. The chair will kind of map out when that public comment occurs. There's no discussion on action except for things that are on the agenda. Sometimes we do have some late breaking items that need to be considered the day of. We just, today's the meeting and something came up and it needs to be considered. Certainly that was happening a lot during COVID and the pandemic, when we were figuring out when things were shutting down and how we were handling emergency responses. And so some of the legislative bodies said, hey, there's a requirement that there has to be a majority, I think it's a super majority vote to put an item on the agenda that day of, and it has to have come in to the kind of conscious after the agenda was published. Next slide,
Quick
please.
question.
Oh, please.
A lot of times, like almost every meeting, members of the public get up and then they try and engage us. They try and ask questions of us. And typically our practice has been to, not engage, not answer their questions. Maybe we make a brief statement or something, but it's not to have a back and forth dialogue and debate on the issue. Would you say that's a good practice?
Chair and commissioners, yes, I think that is a good practice. The Brown Act certainly doesn't require commissioners to engage with members of the public. It has a public comment period for agenda items. Typically through this type of business meeting, comments go through the chair, right? And so it's probably better and more efficient not to engage, but certainly if a public speaker brings up a point and there's a question about it, then sure, it's appropriate to say, I have a question about what that speaker said, right? But again, engaging with members of the public can kind of cascade, and this is a business meeting, and members of the public may be here to hear an item that's down on the agenda. So it is about expediency and ensuring that every item is heard and vetted and heard efficiently. But
If I understand that right, if we engage, then it opens up the time restraint much wider. Is that correct?
Chair and commissioners, I believe the practice here is 3 minutes per comment, right? So 3 minutes per comment. Typically, the applicants are given a little bit more time to give a presentation. They have due process rights. It's typically their property interest that's before the commission. So typically they have a little bit more time to vet that out. But certainly if the chair decides that more time should be given to everybody. The last thing we want is somebody to come back and say, well, the commissioner or the chair gave that person 4 minutes. I had 3. My due process rights or my interest rights were violated because that person got more and I wanted to say more. So again, there's some folks who come in, they speak and they want to speak again. That comes up occasionally. If through the chair provides that additional time to speak, theoretically, everyone should be given that same opportunity to speak again.
I think, and anybody else could jump in and help me here. I thought I read that somewhere, that if we engage in conversation, it gives them then 10 minutes or something like that. Did I read something somewhere like that?
What we
So-
do is if we ask a question for clarification, you've got to make sure that that person only addresses that question, doesn't start an additional
Mhm.
dialogue and
Yep, I read that.
carrying on. It's just respond to the questions asked. Then it doesn't add additional time to their presentation.
What did I read? Do you know what I read on that, Adam?
Yes, so the 10 minutes that you're referring to, Commissioner Davis, is the applicants are given 10 minutes for their presentation. Then the public will have 3 minutes to speak. The Chair Crandall is correct. We have, as we discussed earlier, their questions to the public will give them an opportunity to respond. And then as staff would just recommend that when they've answered the question that you have asked, it's nice to encourage them to wrap up their comments. Otherwise, you tend to get into a more of a dialogue.
Thank you.
Next slide, please. So remedies for a violation of the Brown Act. These are remedies that are targeted to the city. It's not an individual liability. So typically someone can come and say you violated a Brown Act in this or that way. It would be presented to the city. The city could decide to respond. Ultimately, if the city decided, we don't think a Brown Act violation occurred or didn't go through that kind of meet that cure process, then the city could be sued. It could be a writ action to set aside whatever action was subject to the Brown Act violation, an injunction to bar future violations. And if the city loses, it would have to pay the other side's attorney's fees. So we do want to avoid Brown Act violations for all those reasons in furtherance of public transparency. Next slide, please. So the next body of law that we're going to go through is the Political Reform Act. This, I just mentioned that the Brown Act relates to kind of the body. The Political Reform Act is looking at individual commissioners here. The policy behind the Political Reform Act is that we want the city business to be transacted for the benefit of the public and not for individual benefit, right? And so the general rule is that if you have a financial conflict of interest, is to disclose that interest. And it could be just a brief disclosure and then just disqualify yourself from that decision. That would look like, leaving the room or leaving the Zoom and just not participating in it. It also means, don't participate in it prior. So in terms of talking to staff about it, just have a, arm's length transaction and not engage. Next slide, please. So this body of law is very, very twisty and turny, which is not a legal term, but there are rules and then there are exceptions to the rule. And so economic interests can include business interests. So we're looking at investments of $2,000 or more. We're looking at sources of income, which is $500, which is at least $500 in the 12 months prior to a decision. We're looking at gifts that total $520 or more that are 12 months before a decision, real property interests, which could include property that you own or even property that you lease or you even lease out. other kind of personal financial interests that have all these definitions in the FPPC regulations, and they could have direct and indirect items as well. I just want to touch on a couple of these. So sources of gifts that could be cumulative, right? So let's say an applicant takes out a commissioner and pays for lunch, and it $60 lunch, but that happens a few times. That can, in the aggregate, become $520 or more. So if that happened, then the commissioner could not participate in the decision. And if it was more than that, then the commissioner would have to give that money back. So we can't hit higher than that threshold. Sources of gifts, $50 or more, have to be reported on various forms as well. And so there are many, many rules that come along with these. And there's a lot of exemptions to it, right? So let's say that, it was a spouse who gave a gift, those are obviously fine. So there's a lot of exemptions for it. There's even an exemption for, kind of like a best friends exemption. You've known this person for a very, very long time. It's typical that you trade gifts during holidays. And so I can't emphasize how much there's a lot of rules and exceptions to the rule. So if you ever have any questions or concerns, you can come to me, you can come to Mel, either the planning staff as well, and communicate that to them, and we can help you walk through that. And again, though, what the city can do is give our best opinion and advice. Ultimately, it's the FPPC that has the final say. We could only advise, and ultimately it's individual commissioners' decision whether or not to disclose and disqualify themselves. A note, please.
Sorry. What about what I don't see on here, like political contributions, which isn't an issue at the planning commission level, but at council level it is. So let's say an applicant makes $1,000 political contribution to a city council member for their campaign. Is that council member then disqualified from voting on an issue?
No, those are great question, Chair, Commissioners. That is not that's not a reason for disqualification. It's a rule. I would assume that it's balled up in the First Amendment type of rights, where campaign contributions and those type of things are very protected under our federal constitution, and so that would not be a disqualifying financial conflict.
Okay, thank you.
There are issues with direct and indirect financial conflicts of interest. So, for example, I've had a situation where one of my council members, for example, worked for a company that had a contract with an applicant, and it was a large dollar contract. So it wasn't, a source of that council member's, salary, right? And it wasn't the council member that was directly contracting with that applicant, but that applicant was so financially kind of intertwined with the employer that it could be a source of income to that council member. So those are the types of things that we're also looking for, which could be an indirect conflict of interest as well. I also had a question, for example, I had a commissioner who worked for a large university in their real estate practice, and many of the developers that were coming before that city, she was working with in this, private or this public institution. It was a college. And so those are, I just raised that to show you that there's a lot of interesting ways that this can come in. And again, if you have a specific question, we can't analyze it, we have to analyze it on the specifics of the fact pattern. All right. Next slide, please. A longer note about real property interest, because this is kind of what comes up a lot in the Planning Commission, is the FPPC has broken this down into kind of 3 categories. If you live 500 feet or less of one of the applicant proposals that might be coming before you, then your financial effect is presumed material unless, you know, there's this clear and convincing evidence that there's going to be no measurable impact on the property. So the typical rule is if you live within 500 feet of a property, then you're probably going to be disqualified from it. You want to disclose and disqualify yourself from it. The next step up is 500 to 999 feet. And so let's say you live 750 feet away from a proposal, and we're going to be looking at if that decision would have any impact on the development potential of your property, on the income producing potential of your property, your lease, your rent, right? The highest and best use of your property, the character of the change. It will alter traffic, intensity of use, parking, or the market value. Those are the types of things we're going to be looking at. So let's say that, you know, there's a pocket park within 750 feet. It comes before this commission. We're going to look, you know, is this pocket park that's being built within 750 feet of your property? Is it going to have any, what impact is it going to have on your property? And the next rule is 1,000 feet or more. We're going to presume that the financial effect isn't going to be material unless there's clear and convincing evidence of a substantial impact on your property, right? So again, that pocket park, if it's 1,000 feet or more, probably not going to impact your property. But if Disneyland suddenly decided to open up in San Clemente and it was 2,000 feet away from your property, then we're going to presume that it's a financial impact on your property. So we're looking at how kind of big that land use decision is going to be. That's
If Disneyland was moving to San Clemente, then nobody could vote on it. I mean, everybody in town would be impacted.
right. And in those cases, there's a rule on that. Actually, if everyone's disqualified, then we can take straws, pull them from a hat, you know, and figure out who's going to be the quorum that's going to decide this issue.
Okay.
FPPC has thought of everything. Any other questions? All right, next slide, please. Government Code 1090. This is the general rule that an official can't be interested in the city contract. So let's say you own your own business and you want to do business with a city, then that's not going to be allowed. But there's also remote interests and a list of non-interests. So, you know, I had a public official who developed an app that was very, very successful. It was sold to many cities. And there was a decision on whether for that city to have it. And, you know, after, I think it was 12 months, he could decide on it. After he had kind of sold the business and distanced himself, it became either a remote or non-interest. So again, I just mentioned that because there's many exceptions to the rule. Next slide, please. All right, so the chair had brought up these issues of due process. We're going to be talking about this new category of items. So the decisions that are coming before you are quasi-judicial proceedings where the applicant is afforded due process. Due process means notice. We need to give an adequate time to the applicant to know when he or she is going to be, the matter is going to be heard, and an opportunity to speak. And it sounds like there's a city rule that provides applicants even more time than members of the public to speak, which is great. It's fine to have those discussions, right? But with the applicant or those in the community, right? But again, you can't make a decision or in the affirmative, you have to listen to all the evidence that's presented in the public hearing, right? So staff presentation, the applicant, the voices opposed and in favor of it, and base the decision on the full kind of package that's presented. And in some cases, Mal or the city attorney will say, hey, to be very clear, let's disclose your ex parte communications, which are communications outside of this hearing. And we would go down the row and say, each person would say whether they met with, the applicant or what ex parte communications they had. And the reason we might do that is because we want the applicant to be aware of what extra communications that the commissioners have had and give them that opportunity to counter that or to add to that, right? There's also an issue of bias. What we just talked about in terms of the FPPC rules and regulations in the Political Reform Act was about financial conflicts of interest. But when we talk about bias, that's a different thing that may not be financial, right? So we've had situations where a church application has come up and one of the public officials was very, very involved in that church and probably wanted that application to go through, right? Again, this is what we might call a common law conflict of interest. And we would let that commissioner know, the optics of it may not be great, but ultimately it's your decision whether or not you can be impartial or not. So it may not be a financial conflict of interest, but there could be bias issues as well. And what we're looking at, in terms of bias in, if the applicant didn't get enough time or didn't have enough notice about the hearing, it's a risk of legal challenge, right? There's some interesting case law out there where an applicant has come in and it was a council in Los Angeles, and one of the council members was taking a phone call, another council member was talking to a staff member, another council member left and came back 20 minutes later, and the applicant successfully challenged that and said, they obviously weren't paying attention when I was telling them about my application and fighting for my property right. And so they had to redo that hearing because, it was a violation of due process. So I just want to give a note on that. Any questions?
Yeah, so back to like ex parte and disclosure. So for example, if I meet with a developer, then when it has the public hearing, do I need to say, hey, I met with the developer and talked about?
Chair and commissioners, I think that is a good practice. And, it doesn't have to be a dramatic mic drop. I met with the applicant, but it could just be simply in the deliberations. Yesterday I talked to the applicant, he or she walked me through the project. I've also considered everything that was said in the public hearing. I heard what staff's report was, and I'm making my decision on, what I've heard today and just making it very clear on the record. And the record is really important to us because ultimately that is what determines, a case, right? So let's say the city gets sued, we would end up taking that transcript and bringing it to the court. And that's kind of like this closed case. And so it's important to channel those things publicly and say, here's what I considered. So I think it is good practice. Any other questions? Okay, next slide, please. We're almost done. I know I've kept you captive for a while. Thank you for listening. Rules of order and debate. Again, the chair is the parliamentarian. And having that parliamentary procedure, again, it is a business meeting. We're looking at it to be efficient and streamlined. So we want to allow every member to be heard, make decisions without confusion. That's why we use motions, right? So you have a motion, it needs to receive a second to be viable. You might have competing motions. They're voted in reverse order. So the second one that was moved or second one that was brought up would be voted on first and the first one last. You can have friendly amendments and substitute motions. And so there are rules of order and debate. And that is to make everything just streamlined. Next slide, please. These are a general kind of script of how to handle a motion. I know that, most of the commissioners here have been on this body. And so this isn't going to be too new. So I won't go through this too deeply, but again, a motion, a second, there's a restating of the motion, and then there's debate on it. It's important for one person to talk at a time and for the the speaker to be recognized by the chair. The chair will put the question to a vote and then announce the results of the vote. Next slide, please. A couple of slides on findings. Findings are what you're going to see in the resolutions that support the item, right? So you're going to see a staff report and then you're going to see the resolution, and the resolution will have, you know, kind of the recitals, and then in a CUP, for example, certain findings have to be made in order to approve an item. It's a couple slides down the line and you don't have to move over there, but for a CUP, for example, we're looking at whether the proposed use is permitted within that subject zone, the site's suitable for the type of intensity and use proposed, it won't be detrimental to the public health, welfare, and safety, or negatively impact surrounding land uses. And so the reason why we're very big on findings is, again, it's to provide this commission with the framework for making the decision, help guide the commission's analysis, enable the applicants to understand whether they were properly approved or properly denied. And it also helps dissuade parties from challenging a well-reasoned decision. The biggest reason why I want really robust and good findings is because if an item is sued on, so the commission makes a decision, we get sued, again, that transcript is kind of like this closed package that gets sent to the court. And it might include the minutes or the audio from this hearing, and then all the documents included. So the judge is looking at the resolution and the findings and deciding on that, whether our decision or the city's decision was capricious, which is just kind of, there was no reason or rhyme to it, or it was well supported and, you know, factually underpinned. And so that's the reason why I look at good findings. Next slide, please. In terms of unacceptable findings, again, we want it to be in that resolution supporting the action. That's, you know, when a motion is made, it's, I move to approve resolution 22 blank, right? So that is the actual decision that the commission is making. So we can't, you know, while the other items are supportive, the staff report, the transcript of a meeting debate, those type of things, those are supporting to the resolution findings. Bullet point 3 is unacceptable findings is findings that are completely unrelated to the statutory requirements. I just noted the findings for a CUP, for example. I've been with other legislative bodies who have said, you know, just as an example, well, that use isn't going to make a lot of money for the city. It doesn't have a lot of tax purposes. It's a service use that, you know, we don't really want here. Those type of findings aren't related to the statutory requirements. That's a market issue, and not in, you know, in our code. And so those are the types of things that we worry about in our office. Next slide, please. Again, I read these through. These are just the CUP findings that you'll actually be considering tonight in one of the items. Next slide, please. We're getting to,
Let's go back to that
please,
previous slide.
please, yes.
A question that I've always been uncomfortable, but with say cell towers, and whether or not they should be within a certain distance. We've always had commissioners that say, I don't want to say it's going to be safe for the, but we're obligated, or I shouldn't say we're obligated. We cannot say that it's not safe because the state or federal government has said that's a non-issue. Why is it even in the resolution then? Since that finding can't necessarily be made.
We'll probably get into that particular item, but generally, chair and commissioners, you have the statutory requirements, right? So CUP findings. Let's go down to C, which is the proposed use, for example, will not be detrimental to public health, safety, or welfare, or material injurious to properties and improvements in the vicinity. Certainly something like that could be used as additional supporting evidence, or it could not be, right? there's a certain art to making findings. And one of the things we like to see is robust findings, right? I think one of the things that we didn't like was just conclusory findings. And it just said the proposed, sometimes we see, not here, but we might come across a resolution or a finding that just repeats the requirement and says, this is not going to be detrimental to the public. And it doesn't have that additional factual kind of undergirding, right? And so it could be used as support, statements of fact can be used as support. And sometimes you can use a variety of facts or you can use a few facts. Typically, we like to see robust findings. So not to answer your question about the wireless application, which is going to be heard shortly.
This is in general, not
Okay,
even
great.
specifically
Yeah.
on that one,
Yes.
because it's probably not an issue on that. one.
Right.
But we've had some that are within 50 feet of a preschool.
Mhm.
And, public outcry, but it's out of our hands.
Mhm.
So how do we state, well, I can make this finding, this finding, but can't really, I've got to ignore that finding.
Well, Chair, I'll jump in here. There's an exemption, or I should say, there's a restriction on what the Planning Commission can make a decision on related to wireless facilities. If they are provided within a certain range of power and frequency. If what they're proposing does not allow them, if they're not in that range, then that's something else entirely. The FCC is essentially saying that there's a class of wireless facilities that the federal government has reviewed, and they have deemed it essentially okay for locations around residential properties. And that's what you're precluded from weighing in on if it's within those parameters. If somebody's proposing something outside of those parameters, then the finding could be made that there could be a threat. But as long as they're within the FCC's guidelines, that's when that finding, it relies on the federal government's determination, but that's when that finding essentially can be made. So
It might be worth discussion at some other time, but what you just said might be actually the finding that we find that it falls within that framework,
yes,
and therefore, and we make that finding and move on.
Yeah.
So something to consider.
yes, this is a nuanced issue. We do have to work around larger government's restrictions from time to time. And so staff and our city attorney's office will do
All the time.
what's necessary to make sure that the decisions you make are legally sound.
Any additional questions?
Yeah.
Okay. All right. Thank you. Second to last slide, which is the California Public Records Act. So next slide, please. Okay. This is just kind of one last category of open government and transparency laws. California Public Records Act that provides that every person has a right to inspect public records of any state or local agency. A public record is expansively defined to not just include hard copy documents, but also electronic ones as well. So email, text messages, photos, those things, if they pertain to public business, they don't necessarily have to be living on the city's server, but certainly if you're using your personal accounts or even devices to transact city business, then that could be subject to the Public Records Act. It's not as if we're going to ask you for passwords and get into your devices, but if a Public Records Act request comes in and you may have documents, the city clerk would come to you or send you an email and say, we got this request. Can you check your Gmail account or text messages to provide any documents to the city to respond? If it's on the city server, then the city captures all that. So just a note on that is that those documents that you create on a city server aren't private and could be kind of gone through for responding to public records requests. And we do recommend, does everyone get a public email here? San Clemente email? I'm not sure.
Yes, they
Okay, great. I wasn't sure about that. So it's better to use your San Clemente email account for transacting city business than your personal accounts.
Just on that note, this city staff will only communicate through that city email address. If you accidentally use a personal email address, we will respond using your city email address. So it's recommended that you check it. I would say every day would be nice, but every other day. If there's something special, we might call and just let you know that we've emailed something, but expect regular communications through that city email address. And if you ever have any problems logging into it, please contact me and I will connect you with our IT department to make sure that you have that access.
And one item, during a meeting, avoid using any of your personal electronic devices on the dais or whatever, because they can be called in as public record. And all of a sudden, your device is open for total scrutiny. So avoid that at all opportunity.
Good point. Thank you. Next slide, please. Oh, we talked about what's a public record, and go ahead and last slide, which is just a thank you for listening for the hour. We're right on time for the next meeting. And so if you have any questions, feel free to get in touch with Mal or myself. Our contact information is on this slide. Thank you so much.
Thank you very much.
Would you email this to us?
Yes, we can.
I will have planning staff email a copy of this presentation tomorrow morning to all the commissioners.
Okay, so let's close the study session.
make a
Right
comment?
now, 6 o'clock.
Should I make a comment
Um,
on the?
sure,
on stage
go ahead.
session? Sorry. Real quick. We're obligated every couple of years to have a 2-hour training session on this, right?
That's correct.
Would it be possible to have another 1-hour training session on this and have that count?
No, actually, well, it is a very specific presentation. Unfortunately, it just goes much more in depth. The one experience I've had is the FPPC does provide this training, and I know that somebody took it and stopped at an hour and 30 minutes instead of doing 2 hours, and his certificate wasn't accepted. So that's my context for saying no. And it's the presentation is a little bit different than this.
Okay, thank you.
Okay, so we will close the study session. Adam, can we take 5 minutes to take advantage of the snack and then open the meeting in 5 minutes?
You can take as much time as you want. 5 minutes sounds reasonable. We could call it 6:10, just to
Let's start. at
even
6.
it out, 6:10.
I just like your reaction when I tell you, but I am a little bit. But that's fair.
Okay, IT, you ready?
Hello.
It's like Tom's back there, huh?
Let's call to order the regular meeting of the Planning Commission for the City of San Clemente, California, Wednesday, August 3rd, 2022 meeting. We have a new commissioner, Brent Davis, with us tonight. And Brent, would you lead us in the Pledge of Allegiance?
Absolutely. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Atanian, would you call roll, please?
Yes, sir. Commissioner Camp.
Here.
Commissioner Cosgrove,
Here.
Commissioner Davis,
Here,
Commissioner McCacken is not present. Commissioner Prescott,
Here.
Vice Chair McCann,
Here,
and Chair Crandall.
Here. The next item is special orders of business. We have the first item, A, selection of planning commission chair, vice chair, and chair pro tem. I'm going to be stepping aside as chair. And I wanted to, since we haven't really talked to each person, just query everybody here and start with you, Karen. Are you interested in either chair, vice chair, or pro tem?
Thank you for asking. Due to my sometimes intermittent travel schedule and traffic from San Diego, I think it's best that I step aside for this.
Okay, but maybe you'll keep your thoughts open on one of the vice chair pro tem, just,
Probably, well, at this point, I would say the traffic is building. So
yes, it is.
I don't,
Okay,
I don't want to inconvenience anyone.
very good. Brent, are you interested in any of those three, or you want to get your arms around this process first?
that sounds like a great idea. I'm gonna wait a year or so.
Okay, Commissioner McCann,
I would throw my hat in the ring for chair.
very good. Commissioner Cosgrove,
I would be willing to do vice chair.
okay. Commissioner Camp,
First of all, why are you stepping aside?
Yeah,
That's
not
just
so
a-
fast.
give some new blood. If I'm only gonna be here a year, I want to make sure somebody gets some time under their
Okay, so you're only gonna be on the commission for one more year.
possibly. So I'll be able to help mentor a little bit. New chair.
Okay. Yeah, I suppose I'm open to.
Okay. Since we have, that makes it a little easier since we have one person who has stepped up. I was gonna do a secret ballot, but so people didn't feel obligated to any one person, but I would nominate Commissioner McCann to be chair for the next year. Do we have a second?
I would second that.
Second by Commissioner Prescott. And we'll do a vote, roll call. Commissioner Prescott,
I,
Commissioner Davis,
Aye.
Commissioner Camp,
Hi,
Commissioner Cosgrove,
I,
and Commissioner Crandall is an aye also. So the meeting will go, let's see, do we want to change seats, Adam?
Chair, could I just request that previously Vice Chair McCann has a vote on this, on his appointment?
You didn't ask me to vote.
I'm
He gets a
sorry.
vote.
Commissioner McCann, how do you vote?
Aye.
Okay,
Right.
unanimous. Thank
Thank
you
you.
for the record. Hand that back. The meeting is yours.
Thank you. I don't feel the need to switch seats unless staff does.
For IT, it would be great if everybody stayed where they were.
Yeah.
So we don't have to adjust. However, we would do it with a break if the committee would, or the commission would like.
I think we're good. Thank you. And thank you for your vote of confidence. So with that, next position to select would be the vice chair. Commissioner Camp, you were unclear as to which position if you would be willing to do.
I'm
Commissioner
happy
Cos,
to be vice chair.
excuse me?
I'm happy to be vice chair.
Okay, well, Commissioner Cosgrove offered vice chair specifically. Would you be happy with Chair Pro Tem? Is that fine, or you want to do for vice chair?
No, that's fine. That's fine.
Okay.
What is pro tem? That means I'm,
Third in
Means when
line.
vice chair is not there, pro tem steps up.
That's the easiest one.
that's fine with me.
Okay, with that being volunteered, thank you for volunteering. Let's just have a roll call vote then for, I would nominate Commissioner Cameron Cosgrove for vice chair. Commissioner Prescott,
Aye.
Commissioner Davis.
I'll second it and I.
Okay,
Oh,
thank you.
For that.
Thank you.
Now I'll say aye.
Sorry.
Crandall.
Well, I was thinking of a good title like Chair Emeritus or something.
I'm a commissioner now.
Commissioner Crandall,
Aye.
Commissioner Camp,
Aye.
and Commissioner Cosgrove.
Aye.
Okay, that's unanimous. Congratulations, Vice Chair Cosgrove. A point of clarification for Adam. At different times, I thought it was Vice Chair Pro Tem, or is it Chair Pro Tem?
It's Chair Pro Tem.
Chair Pro Tem. Okay, so then Commissioner Camp has volunteered to serve as Chair Pro Tem. Do we have a nomination for that?
Yeah, I'll move Commissioner Camp as Chair Pro Tem.
I will
that.
second.
Oh, good.
Unanimous.
Okay, Commissioner Prescott with the second to Commissioner Vice Chair Cosgrove's motion. Let's have a roll call vote.
Aye.
That
Or-
was
sorry, identify me.
Commissioner Prescott, Commissioner Davies,
Oh, I got it.
I,
Commissioner Crandall,
Aye.
Vice Chair Cosgrove,
Aye.
and Commissioner
Nay, no, just kidding.
Commissioner Camp.
Way to go.
Aye, sorry.
Okay, and I am a aye as well. So that's unanimous. Congratulations and thank you for volunteering. Moving on, we need to select for design review subcommittee members. There's 3 active members and then 1 alternate member. Let's just go around and see who might be interested and willing to serve on that. Commissioner Prescott.
Difficult at 3:00, so unless you really need me.
Okay, thank you. Commissioner Davies.
I'm gonna take a year on that one also.
Okay. Commissioner
I would
Crandall.
love to be on design review.
Okay. Vice Chair Cosgrove.
Yeah, I have an interest to serve on that subcommittee as well.
Okay. Commissioner, but Chair Pro Tem Camp.
Yeah, I'd like to continue.
Okay, thanks. I was formerly on it and I have been on it and it's been great. I would be willing to be an alternate member, but prefer not to be an active member at this time. So with that, I guess I would propose that the 3 people that volunteered for full-time service be on the design review subcommittee being Commissioner Crandall, Vice Chair Cosgrove, and Chair Pro Tem Camp. I would propose to nominate them as full-time active and myself as alternate. That's a motion in the form of a
Second.
motion. Second by Commissioner Crandall. Let's do a roll call vote. Commissioner Prescott, I wanted to say Karen.
I'm an aye.
Commissioner Davies,
Aye.
Commissioner Crandall,
Aye.
Vice Chair Cosgrove,
Aye.
Chair Pro Tem Camp,
Aye.
and I am an aye as well. So passes, all those pass unanimously. So thank you again for volunteering, especially on the design review subcommittee. I know that's a bunch of extra work, so thank you. Moving on, We have the minutes of the regular planning commission of June 22nd. I would entertain a motion on that.
I'd like to make a motion to approve. the
Second,
June 22nd, 2022.
Motion by Commissioner Prescott, second by Vice Chair Cosgrove. Any discussion or anyone? Okay, then let's do a roll call vote. Commissioner Prescott,
Aye.
Commissioner Davies, you weren't there, so you should abstain.
That's what I'm guessing. I'll abstain.
Awesome, thank you. Commissioner Crandall,
Aye.
Vice Chair Cosgrove,
aye.
Chair Pro Tem Kemp,
Aye.
and I am an aye as well. Moving on. Do we have anyone wishing to speak to the planning commission this evening for any items that are not on the agenda? Okay, seeing none, we'll move on to the consent calendar. We have the consent calendar as outlined in the agenda. Does anybody want to pull this and discuss it, or I would entertain a motion on the consent calendar?
Mr. Chairman, I'll move the consent calendar.
I will second that.
Okay, that was motion by Vice Chair Cosgrove and second by Commissioner Crandall. Another roll call vote. Commissioner Prescott,
Would be an aye.
Commissioner Davies,
Aye.
Commissioner Crandall,
Aye.
Vice Chair Cosgrove,
Aye.
Chair Pro Tem Camp,
Aye.
and I am an aye as well. Now on to public hearings. We have a public hearing for item 8A. Adam, do we have a staff report on this?
Yes, we do. I'm joined by our senior planner, Sarah Toma. She will be providing the staff presentation. The a member of the applicant's team is here as well. And we have a PowerPoint presentation, and if IT could bring that up, we'd appreciate it.
Perfect. Thank you, Adam. And Chair McKinnon and Commissioners. My name is Sarah Toma. I'm Senior Planner with the Planning Division. And today I'll be presenting to you the conditional use permit for T-Mobile wireless facility. Next slide, please. So T-Mobile is requesting the installation of a new wireless telecommunication facility on an existing Southern California Edison SCE utility tower on city-owned property. The site is located in the Talega specific plan, which is identified as in the land use designation of the property as privately owned open space. Next slide, please. The project location is located west of Avenida La Plata and north of Camino del Rio. I tried to provide two aerial views of the site location just for context. Next slide, please. The wireless facility would include 6 panel antennas, 6 remote radio units, 2 equipment cabinets, 4 baseband units, and then 1 GPS antenna and correlating jumpers and cables. Also, the equipment and the utility cabinets will be installed on the ground directly beneath the wireless facility and wholly contained within the footprint of the tower and will be enclosed by a chain link fence installed by the applicant. Next slide, please. So as you can see here, under the elevations, this is an existing SCE tower that's 118 feet tall. And the proposed T-Mobile panel antennas will be at the 39 feet height with the proposed equipment, which is located at the base of the site. I tried to highlight it as close as possible to see where the locations they will be on the towers. Next slide, please. So under project analysis for the site location, so T-Mobile has selected the site due to its favorable location and improving service within the communities to the east and west of the subject site along Avenida La Plata, locating the wireless facility on an existing SC tower minimizes the potential visual impacts that can be caused by installing new antennas, support structures, and the proposed wireless telecommunication facility will be integrated into the tower by being painted to match the tower, thus further reducing potential impacts. Next slide, please. So under our zoning ordinance, a CUP is required to install new antennas. T-Mobile will enter into a lease agreement with the city prior to installing of the antennas and the equipment. The antennas will comply with the FCC regulations. Primary consideration in review of the CUP is to ensure the project compatibility with the surrounding land uses. Surrounding land uses are open space with the closest residential communities located approximately 1,000 to 1,100 feet from the proposed SC tower. Next slide, please. Under the CUP findings, which you can see on page 1 of the staff report, they're listed on page 1 of the staff report. The proposed wireless facility will not alter the height of the existing SCE utility tower, as it will be attached to the tower. The proposed wireless facility will not create adverse visual impacts to the surrounding area or to the city at large. And the proposed wireless facility is consistent with the city's general plan and the wireless master plan design standards. Next slide, please. Staff recommends that the planning commission hereby finds and determines that the proposed project is categorically exempt from CEQA pursuant under section 15301 and 15303. Next slide, please. Staff's recommends that the planning commission do the following. 1, determine the project is categorically exempt from CEQA under section 15301, which is a class 1 existing facilities, and section 15303, class 3, which is new construction or conversion of small structures. And then 2, to adopt a resolution PC 22016, approving conditional use permit number 22-287, T-Mobile wireless facility on SCE tower, subject to the conditions of approval therein. And that concludes staff's representation. Thank you.
Thank you very much, Sarah. Does anybody have any questions for staff?
I have one question, Mr. Chairman. Sarah, does the utility, I'm assuming the utility has no objection?
No, they do not. And we have in a letter approving that they will allow this on their tower.
We wouldn't happen to have a copy of that letter, would we?
I don't have it on me, but I can provide it.
I think it would be nice to have that included.
Yes, absolutely. It's if it makes it's actually part of our Track It system, so it's uploaded and it's can be viewed on our Track It software.
If they have no
It's-
objection and it's their equipment, I would have no objection.
I have a thought, when we're talking about visual impact,
Yes.
chain link fence doesn't really do it for me visually.
Mhm.
Or is this chain link fence could maybe have some of those brown slats in it or something to kind of disrupt the chain link fence, like if I have a chain link fence between me and my neighbor,
Mhm.
I could beautify that just a little bit by putting those little slats in, weaving them in. I was thinking maybe a tan something or something. I don't know, just a thought. Cause this green thing behind some chain link,
Was it my understanding that they're going to paint it?
The painting was for the actual equipment that's going to be on the tower itself. For the chain link, maybe the applicant can speak to that. I know that SCE is very particular. We had made some recommendations possibly about landscaping and or putting a camera, and they were very specific about not having anything that would alter their site in any way, shape, or form. They were very specific about their engineer to only allow the equipment that T-Mobile is requesting to approve.
Okay, thank you.
so are you saying you can't plant plants around it to
No, we actually got an official letter from them saying that they don't want to allow landscaping just for access and or I think
That's
fire
the-
hazards.
okay, upkeep, fire hazard, I guess. So
Yes.
what do y'all, can I speak to everybody like that? What
Well,
do y'all think about this?
we'll have a later time during when we'll be able to kind of discuss it and we could kind of go back and forth
Okay.
with you. Right now, just got questions for staff, specific questions, which you had,
Okay.
but we can kind of collectively discuss it later.
Okay.
Yeah, any other questions for staff?
No.
Okay. Anyone else? Commissioner Vice Chair Pro Tem. Yeah.
So the tower is obviously visible from La Plata.
Yes.
Is this the view that you have on the image here of the tower?
Yes.
Okay,
There was under attachment, let's see. I think it was attachment 2, which was the photo simulation. It showed the visualization of where the tower
Oh.
is. Yeah,
um,
it should be at the end of the staff report.
okay.
The
And
applicant
two-
provided different photo simulations showing where it is from if you're standing next to it, even as they went as far as showing it from where in a residential community, they can see it. I mean, they can obviously see the tower because it's huge, but you're not likely to see the equipment itself.
Okay. So Edison maintains, obviously they maintain these towers.
Yes,
Do they also maintain this equipment or is that me?
the equipment will be maintained by the applicant.
Okay.
Yeah.
All right, and the equipment that's up on the tower, it's protrudes out from the edge of the tower. So it's not actually within the envelope, I guess. You're just talking about the doghouse or whatever at the base, the equipment cabinet.
It's,
Because the the part of the antenna or whatever, it does stick out beyond the footprint of that tower.
Usually they.
yes,
don't,
it,
right?
it is very common that that's the way they display them in order to.
Oh, I know.
Okay.
Yeah, no, I've seen
I'm-
Oh.
I'm s- Going back to the
it. I'm just
utility.
curious if it
The
can.
utility.
Can
approved
you
that.
wait, please, for a second, please?
Yeah, I'm sorry. Did I answer your question? Commissioner Khan?
Yeah, you answered my question. Well, my question is, can it be within the tower framework? Or does it have to protrude out beyond it? Maybe the applicant can address that. That's a question I have. Also, the cabinet, is that on like a concrete pad or is it just on stilts or hard to tell?
Those would be questions for the applicant. They can
Okay.
describe more of the specific construction of these features. At this point, the request is simply for the location approval.
Okay, thank you.
I can add it to part of our like building permit review. That could be something that I can make sure of. I'm sure it is, most likely it will have some kind of concrete base.
Okay.
Because that's usually how they,
Commissioner Prescott, did you have a question?
Well, I was just wondering, I mean, the utilities are very specific about, sharing their tower with another entity. And that letter would have probably provided more insight to some of our questions. Is there anything else in that letter that you could share that addressed that footprint?
the letter is basically just giving permission to T-Mobile to allow them to put the equipment on on Edison's tower. That's putting, they didn't disclose any other information pertaining to the design other than what what T-Mobile submitted to their engineers and they approved it. That was what they're allowing them to do.
Thank
Yeah.
Any other questions for staff? I have a couple. How far is the tower from La Plata? Approximately?
About, I want to say 30 to 40 feet. But I don't have an exact, it's not,
I think it's further.
Yeah. it looks further than
It looks to be about 100 feet.
I would guess that too.
Yeah, the roadway width is probably 70 feet. So it's at least 100 feet away.
Yeah.
Figure 1 in the staff report shows a location map. This is the closest tower, I believe, on this side of La Plata to La Plata. And the applicant can speak more to the coverage needs, but it's as the towers move further away from La Plata, they start going a little bit downhill.
Okay.
And I believe that might be one of the issues related to coverage, but the applicant will, I'm sure will address that in their presentation.
Okay, thank you. You said that the applicant is going to sign a lease with the city. Why would they be doing that? Because it's Edison's facility, I assume, the tower. What-
Right, we own the land and that's part of our requirements. But
Okay.
that comes after we approve the CUP and we work, internally on that with them.
Okay.
Yeah.
Can you tell us how much they'll be paying for that lease?
I don't have that information.
Okay, thank you. Question for the city
That-
attorney. Go ahead.
Just more information on the process for the land lease agreement. Those are reviewed by the city council. And so that will be reviewed and approved by the council as far as the amount and the details of that lease.
City attorney. If any of us have T-Mobile, I assume we can still vote on this issue?
Thank you, Chair. That is correct. That there's no financial conflict of interest.
Gotcha.
Thank you.
Okay, thanks. Anybody else with questions for staff? Okay, seeing none, we'll open the public hearing. I do have a public comment card from the applicant. Damian Picardo. If you'd like to come and address us, there was a number of questions that hopefully you can clarify as well.
Of course. Do I need to press anything here? You guys can hear me?
You're good. You have 10 minutes.
Okay, perfect. Oh, that's it.
Don't push it.
Good evening, Chair and Commissioners. Thank you, staff, for the presentation. My name is Damian Pichardo with Coastal Business Group. I'm here representing T-Mobile tonight. As a resident of San Clemente recent, I'm very happy to be here and be presenting to you guys and really bringing a benefit to the community is what I feel, and a good project. I think it's one of the better designs that I've worked on for wireless carriers, all including T-Mobile. To get into some of these questions, I tried to write a lot of them down, so feel free to add in as I go through them. But I'll take them one by one from basically what I got down from the top. So there's some questions about SCE and their approval through this process and making sure that we have their approvals. I work with SC every day. T-Mobile works with SC every day. We have a master agreement with SCE, which and this relationship that we go through them. Everything has to go through their approval before they would allow any sort of installation on their towers. It goes through a very strict approval, as Sarah mentioned. They have engineering look at it. They have their land team look at it. They have a special wireless team that looks at it. So there's a lot of groups within SCE. It's a very thorough review. They have a lot of limitations for us actually, and we prefer to usually have more equipments on our towers, but they do limit a lot of what we can do here. In terms of chain link fences and installing slats, I would have to confirm with SCE on that. I think from T-Mobile's perspective, we would be open to installing slats if SCE were to allow us to do so. I'm not sure how we would handle that in terms of approval on adding that design. We can definitely add it if feasible into the construction drawings through the plan check process. Visibility from La Pata, you can be seeing it probably going north and south. I did personally go through the communities, both east and west of this tower. And where you would be able to see this is very limited to kind of further away from La Pata and each community. By the time you'd get there, if I didn't have glasses on, I definitely couldn't see it with glasses. As you can see in a photo sim, they're pretty small and you basically see just the antennas towards the center of the tower. I don't think you'd have a clear view of the ground equipment at any point in those communities. There's a question about, does Edison maintain our equipment? No, they do not. T-Mobile would maintain our own equipment. If we did need to maintain, we always have to go through Edison. No matter how small or big it is, if we have to go touch that equipment, essentially Edison needs notification and or approval of what we are doing. If we're changing equipment, we definitely will need approval from Edison prior. There's some questions about equipment protruding outside of the tower and if we could install within the tower for the antennas. We could not install within the tower steel for the antenna portion and SCS strict engineering guidelines. Number one, and number two, if we had our antennas within, there'd be interference with the steel in front of the antennas. So essentially the antennas have to have a clear line of sight and can't have anything obstructing their path and signal. I think the nature of the comment within the envelope. So if you had a straight above view, plan view of the tower, the antennas are narrower than the base of the tower, and then all of our equipment is within it. So essentially, if you took the envelope as the base of the tower up, all of our equipment is within that frame. The cabinets will not be proposed on a concrete pad due to the grade and the slope of this tower. We're actually having to propose a steel platform. There's going to be caissons that go down, doing a soil report currently to ensure that's all going to pass through plan check, of course. But that'll be a steel graded platform. It'll have holes in it essentially, but it will be steel, not concrete. Typically, we would do concrete, but in this case, due to the grade, we will need steel here. The distance from the tower to La Pata, did a quick measurement here while I was sitting, based on the site plan and the scale on the site plan. It appears to be over 400 feet. I'm just going to use that as the minimum, but appears to be over 400 feet from La Pata. And as for the lease, we are working with Jonathan Lightfoot with the city in our lease discussions. Been discussing with them probably for the past 3 weeks, but as was mentioned, this will come to the commission as well for final approvals. Don't currently have any information on that rate yet, but hopefully we will come to a conclusion that's a benefit for everybody. Hopefully I got to most, if not everything, but we'll stand up here as long as I have and answer as many questions as possible.
Thank you. Does anybody have any questions for the applicant? No, thank you. Good job answering our questions.
Thank you.
Does anybody else wish to speak on this item? Seeing none, we'll close the public hearing. And I open it up for discussion or thoughts and comments on this item. Commissioner Crandall?
Yeah, we've done a lot of cell towers in the city over the years. Ones that are near residential, ones that are in a view corridor. We either find better locations for them, or they do get hidden by landscaping and or faux tree look. So yes, we are aesthetically minded about these cell towers. This one's a little bit unique that it's already on a huge structure. We got some up by a couple of the water tanks, I think, that are masked. And so those comments are good and valid, and we do that. I think this one, it's kind of a city gateway, but really the gateway's closer down towards Target and also we're past that. So I don't think that applies. And I can make on this particular one, all the findings and the one item C, the proposed use will not be detrimental to health. I'm accepting that one, knowing that the intensity of the antenna falls within the, is it FCC?
Yes.
FCC limits that we have to approve it. So I can support this application.
Thank you. Anyone else?
Yeah, I would just say that, it's a very efficient way to deal with these antennas, put them on an existing steel, massive structure. I mean, it's only 39 feet when this whole thing's 120 almost. So, I mean, it'd be nice if it could be within the framework, but I understand that doesn't function properly. If that's the case, it would be because, you see these trees and they're obviously not trees. I mean, I think that's almost more annoying. So, to me, it seems like a good solution, and it gets them the coverage that they want. So I like Commissioner Crandall, I think we can probably support all the findings here.
Okay, thank you. Anyone else?
Yeah, I just would add that the visual impact isn't changing that much. The structure's already there. People are used to it. So no one's really probably going to notice the antennas. So I agree with with everything people have already said.
Okay. Anyone else? So
I-
this would be the time, Commissioner Davies, to make your pitch for
Slats.
slats or
So
landscaping or
it'd be
something.
cool, and I don't know how they're gonna mask it like they do with the water towers, but it'd be great to see some slats or something in there. And it's not on the vertical. I don't want to do a tree out of that whole thing. But just the bottom little box that it's going in, having chain link around it. I was not a fan of chain link, so it'd be cool. He had mentioned that he's gonna pitch to SCE or somebody to get that approved, so that'd be great if we could see it. You guys cool with that? Or what you think?
So I think what would happen is if you're obviously suggesting that,
Yeah.
and I'd love to hear what Commissioner Prescott thinks about this project, and I have my own thoughts, but when everyone's done kind of discussing, I would suggest that you consider making a motion to approve the project, but you'd like to see slats added in to the chain link if possible. And that way staff can work with the applicant, and if it can happen, then it'll happen, and if not, it won't. They don't have to come back to us for reapproval. So consider making a motion in a minute. Commissioner Prescott.
Thank you, Mr. Chair. I agree with the other commissioners. As far as the tower, it is very pretty as it is. And I don't think adding anything to it, it will be one way or the other as far as the aesthetics. I've driven by there so many times that I'm just used to seeing the tall towers. I would have no objection to slats, but I would hate to add any extra expense to a project that's already been engineered. So either way, I would approve this project.
Commissioner Crandall.
Yeah, I was thinking on those slats. Right now, it's a transparent fence. It's a metal tower. The equipment is smaller than the chain link fence area, and it almost seems like putting slats is going to draw more attention to it and make it this funny square block that you can't see through and anything. So I'm kind of neutral on it, but I think it's probably not necessary to enhance it. It's just a change at this point.
Yeah, I appreciate those comments.
Yeah.
Logic.
My thoughts, I'm supportive of the project. I can make the findings in support of the project. Given the as it's been discussed, given the magnitude of the tower and the wires and everything, I think that I tend to agree with Chair Crandall that adding slats and make, oh, well, here's this opaque thing now that you can't see through, as opposed to, I think all the equipment stuff is just going to get you're not even going to see it in the scope of the tower. But if people feel strongly about it, I'm happy to support it either way, with or without slats. So with that, I'm open to a motion.
Chair McCann, if I could, the applicant would like to propose the removal of one of the conditions of approval. It's not related to the cell tower facilities. This is just a condition that's the city tends to include for the public benefit. However, in this location, because though it's on city property, the cell tower is in an easement owned by a utility company. And the condition of approval that we're referencing is,
It's 1.8 on page 2.
and if you want,
Conditions of approval.
and what I'd like to do is have the applicant request the condition be removed. And then we can discuss staff's position on that request. But if you wouldn't
Okay.
mind just.
Do we need to
formally making that
reopen the
request.
public hearing to have that request heard? Do we need to reopen the public hearing to have that heard?
Chair, Commissioners, yes, I would reopen I wasn't aware that the public hearing is closed, but yes, that the applicant's comments would be part of the public hearing.
Okay, so with that, I will reopen the public hearing. Damian, you are welcome to speak.
Thank you guys for your opening. I would like to request removal of condition number 1.8 to install a camera on our facility or SCE structure. As we've mentioned before, SCE is very strict on what they allow on their towers. This being one of them, we do have a letter from them, essentially stating that T-Mobile would not have the right to do so, and neither would a third party. So we'd like to request that removal.
So if I can give a little bit of background to the
Yes.
committee on
assessment
this
for you.
commission. This condition came from other cell towers that were located on city property. And in exchange for locating a cell tower, we want the future option of installing cameras should there be security concerns in the general vicinity. And in this case, they don't own the tower. SCE does. And so staff is supportive of the removal of it because it's not feasible. And we would not be able to, staff would not be able to support making the findings necessary to require that condition to be included. This is something that we are asking for in exchange for the location of a new tower. It's not something that's required, and it's nice if we can get this, but we understand that it's not going to be feasible in every situation. And we were just not aware that this was the case prior to drafting these conditions. So staff is supportive of the removal.
Okay, thank you. I'll close the public hearing. Thank you for that input. So with that, I'm open to a motion on this issue. And if the mover so deems, they should consider striking that condition 1.8.
Okay, I can do that. I'll make a motion. We approve resolution number PC 22016, a resolution of the Planning Commission of the City of San Clemente, California, approving conditional use permit 21287 T-Mobile SC tower, a request to allow a new wireless telecommunication facility and accompanying ground mounted equipment to be installed on an existing Southern California Edison utility tower in the city-owned property west of Avenida La Plata and north of El Camino or Camino del Rio, with the removal of condition of approval 1.8. That also that the project is exempt from the CEQA
Yes.
requirements.
I
Thank
would
you.
second that motion.
Thank you for your motion, Commissioner Crandall. I heard a second by Commissioner Prescott. Let's take a roll call vote. Commissioner Prescott,
Yes, aye.
Commissioner Davies,
Aye.
Commissioner Crandall,
Aye.
Vice Chair Cosgrove,
Aye.
Chair Pro Tem Camp,
Aye.
and I am an aye. The item passes unanimously. Congratulations. Moving on, we have another public hearing for discretionary sign permit on master and sign program. Do we have a staff report?
Yes, Chair, we do. The staff planner is David Carrillo. He is joining us via Zoom. We do have a PowerPoint for this as well, which should be coming up on the screen shortly.
All right, good evening, Chair and members of the Commission, David Carrillo. Commissioner Davis, welcome. All right, so the project is 1010 Santiago Master Sign Program Discretionary Sign Permit 21-289. Next slide. Project site is 1010 South El Camino Real within the mixed use 3.2 zoning district and the architectural and affordable housing overlay district. Next slide. Some background here. So this development just finished construction, I believe, last year. I went through a city council review process. Currently has 7 residential units. It's a mixed use development with 7 residential units on the top floor, along with office spaces, and then a gelato shop and a future restaurant at the ground level. Supporting all these uses are 2 levels of parking as well on site. Next slide. So the request before us is a discretionary sign permit for 2 reasons. One is requesting a master sign program, and then one is to exceed 25 square feet of sign area for a business, where 25 square feet is a maximum within the architectural overlay district. So the master sign program consists of a total of 7 signs. We have 3 tenant wall signs, 1 blaze sign, 1 project ID or identification sign, 1 multi-tenant directory sign, and then 1 parking directional sign. And I'll go ahead and review each one in the further slides. Next slide. So the design review subcommittee did review the project 2 months ago. Does support the master sign program with minor changes, including the addition of a color palette to the master sign program, adding language which discourages the use of backer boards on signs where possible, and reducing the size of a tenant wall sign on the south elevation, which faces Avenida West, West Avenida Santiago. Next slide. The master sign program contains the information listed on the screen. It is a document that provides information on the submittal and approval process. It gives guidance to the sign contractor coming to the city to receive the administrative approval that's required after this discretionary process. There's some guidance on the design of the sign, of each sign. There's mention on the material, on the type of lighting. There's some direction on the size and location of signs as well. And also included, we have a list of signs that are prohibited. And all this is, again, to achieve what a master sign program is meant to do, which is to have cohesive signage throughout the entire site. Next slide. So as part of the addressing or responding to design review subcommittee comments, the applicant's team did agree to adding a color palette, and we see that before us. Examples of signage that would be allowed on site are to the right of the color palette, which would be aluminum halo lit signage. Next slide. And here we have the front elevation. So I'm showing 3 different areas. There are a total of 4 signs, and I'll point them out. On the far left, we have the Buona Forchetta sign. That's the first one. That's a tenant sign for the restaurant, the future restaurant. In the center, we have the 1010 Santiago sign. That's a project ID sign. And then on the far right, within the circle, there are 2 signs. There's a blaze sign and a tenant wall sign for the gelato shop. Next slide. The elevation facing Avenida Santiago, we have 2. On the far right would be the second sign for the future restaurant, Buona Forchetta. And then we have a hand-painted multi-tenant directional sign to the far left at the entrance of the parking garage. So we only have 2 on this elevation. Next slide. And then lastly, we have 1 parking directional sign that would be hand painted as well. And this is the rear elevation that faces the alley. Next slide. So the second part of this request, again, is the request to exceed 25 square feet per business or for a business, in this case being the future restaurant. So we see how the restaurant has two business facades, one facing El Camino Real and the other facing Avenida Santiago. So given the building's setting, its mass and form and height, staff still deems the additional signage over 25 square feet to be consistent with goals within the architectural overlay district. Next slide. And here we have those two signs again identified on the elevations. Next slide. So in conclusion, staff has determined that the master sign program, along with the request to exceed 25 square feet for the restaurant tenant, we do find that the master sign program is in compliance with the development standards, consistent with the general plan policies and design guidelines, along with the architectural overlay district goal. Next slide. Therefore, staff recommends that the Planning Commission determine the project is categorically exempt from the requirements of the California Environmental Quality Act and approve the project subject to conditions of approval. And I did receive one public comment that I'll read when it's time to do that. I believe we have the applicant and his team present as well, available for any questions.
Thank you, David. Does anybody have any questions for David?
Davis
I'm sorry, say that again.
just got a letter to read from the public.
We want to do it in public hearing.
Could,
Okay.
could I have David go back a couple of slides? I just
Yeah.
wanted to see, David, could you, I would say maybe 4 slides back where it shows the sign over the 3 windows?
There you go. Let's see. I believe IT, can you go to the elevation that reads front elevation?
Right.
This one?
So I just wanted to see, so that, those 3 windows belong to the restaurant, correct?
Correct. Mhm.
That's all I wanted to. Thank you.
Mr. Chairman. I have
Sure, Vice Chair.
Couple questions. And if you want to, no, can you keep the PowerPoint up, please? So how does this work? There's different styles that are indicated in the program. What, do you know what style will be where? Is that for the applicant or do you know that now?
That's a good question. We don't have a style per location. It would be up to the tenant and the property owner once an application is reviewed. But a tenant would have the option to choose one of 4 sign types, which essentially are similar, given that the material for all of them is aluminum. And we have the color palette to help with that cohesiveness.
Okay. I kind of have a problem with that because signs are important and the size and location and prominence of a sign is important. And that should so reflect the type of materials that are applied and used. So it makes sense to have a range of styles. So when you have, for example, a directory and you want to just paint that on the wall, cool. But when you have a prominent building sign, maybe that should be lit. Now, what I'm hearing is, well, we don't know. So I will be asking the applicant if he can speak to that. Because I do think it would be appropriate. Second question I have is on the gelato shop, those signs are already installed.
Correct.
Are you aware of that?
Correct. Mhm.
Okay. And is that okay?
Yes, that is permitted. That was a maximum, and we worked with the applicant closely with this, but that was a maximum they could have done before a master sign program was required.
Gotcha. And then can we go forward on the slide deck to the photograph of the, that right there. Now, this is a little off on a tangent, But if you look at this photo, do you see the string of lights? This is, I'm just asking the staff. And then you see that pole that it's attached to. So I did a site walk. That pole, while it's metal, it's flexing. It doesn't look like it's just any kind of a design standard. And I'm just curious if you're aware of this. Is this approved? It doesn't strike me as something that should be there or is safe over time. Wind, kids, whatever. It just looks jerry-rigged on there, temporary. So I don't know, do you know anything about that, David? Could you speak to it?
Yes, I do know that from my recollection on the properties records, we don't have a permit for that, allowing the pole and the string lighting. It would be something that this staff is supportive. We do understand the ways outdoor patios are used, but there is no permit that has been obtained.
So maybe it's appropriate, we can ask the applicant if they want to apply for a permit and maybe make the installation a little bit better. Okay, those are my questions. Thank you.
Thank you. Any other questions?
Just for my knowledge, is in a mixed use situation, those string lights, it looks like they're gonna be just firing right into those people upstairs windows. Is that where they're living? Those 3 windows up there? Or no?
The 3 windows leading to the outdoor patio, that's for office.
That's office.
That's office, yeah.
Okay.
The residential units are towards the rear of the building.
Gotcha.
Mhm.
Any other questions?
Yeah, the reason we're looking at this is because they're asking to exceed the standard.
There's
I'll jump in on this one.
Yeah.
The reason the master sign program is required is because any building with more than 4 signs is going to require a master sign program. And this is to do a number of things. The first and most important is to provide consistency of the signs for the future of the building. Knowing the tenants come and go, it's nice to have a sign program that provides flexibility for future tenants. And that's why there's typically a number of styles, number of colors, locations are identified. That's one thing that's consistent, is that the locations of signs are identified. But as far as what the exact sign looks like, these typically have flexibility. Part of that flexibility is would fall under the category of First Amendment rights, and that would be related to the freedom of speech, and that's the content of signs that can translate into trademarked signs or fonts that companies use. We cannot stop a company from utilizing a particular font, especially if it's trademarked. Furthermore, if there is a concern about the style of the sign, that may get into issues of content-based regulation, which is not something that the city has the authority to do. For staff, these master sign programs are really nice because we can quickly process the changing signs for future tenants. There may be some considerations where we want to look at specific signs a little differently in a master sign program, but it can cut down on especially in the architectural overlay, the number of times that we need to process a discretionary application for a building that has already had signs.
I think it's a good thing. Is there a reason why we didn't look at this at design review subcommittee? Because I don't remember getting this. We don't look at these.
Yeah, we did.
We did. You
Did?
might have not been there.
Oh, I
maybe.
wasn't there that week.
Yeah.
My apologies. So there's gonna be up to 7 signs, 10 signs. Is that what we?
David, would you confirm that, please?
There is a total of 7 within the master sign program, correct?
Okay, but those have not all been identified?
The size and location have, and that's the purpose of the master sign program. But as far as which signs, actually for this, in this example, the applicant decided to use as part of their master sign program the signs that they actually will be proposing immediately after this permit becomes valid. So what you see within the elevations is what they would be proposing as soon as they can at the administrative level.
Okay, so we're approving the
Oh.
palette, the color palette, the styles that are shown, the combination of blade signs, reverse, there's some reverse channel. We're basically saying they can use any of those, but they need to put them in the locations that are proposed in this master sign program.
Correct, and they will be any future sign as well will be limited to the sign parameters being presented within the master sign program.
And that brings up a really good point. You're approving the signage that will be on this building in perpetuity. So I know this isn't the case. Bona Forqueta will be there forever. Should something occur and they leave and another business shows up, this master sign program, as it's currently proposed, covers the new business's sign.
So it runs with the building.
Yes, but they're limited in terms of the types of signs and the locations and the colors and all of that. That's what the master sign program does. It gives staff a document that says that anything that meets the standards in this program, and can be approved administratively. That's
That's all the questions.
Thank you. Any other questions for staff? I have a couple. In the staff report, it says that the applicant did make the changes from the design review subcommittee. I just wanted to see, did the exhibits get changed, or did we just did they do that like administratively agree to, okay, we'll shrink the size of that one and stuff like that?
Yeah, they did. The elevation that faces Santiago was updated to reflect the request from the RSC.
Okay, and this is probably more for Commissioner Crandall, but I know we talked about backer boards at design review subcommittee, and it was talked about, well, if we have them, then it's easier. And if signs change, then there's not a lot of stucco damage. It's hard to match and repair. So did we settle on avoid backer boards?
We didn't say avoid, we said avoid if possible. There's certain options besides backboard channel and all that allow signs to be changed without violating the Spanish colonial revival stucco. So it was put in there, and I think in the text it says avoid where possible.
Okay, okay.
We were certainly aware of it, and he said they'd prefer if they didn't have to do it, but they've got a nice building here, and we didn't want to have the thing torn up just to change signs.
Right, exactly. Okay, so staff is comfortable with that language, avoid where possible?
Yes, correct.
Great, thank you. I have no further questions. So with that, I'll open the public hearing on this item. Do we have any speaker cards on this? Would the applicant like to speak and or address any of the things we've discussed?
Happy to answer any questions you might have.
Okay, so you're available for questions. Does anybody have any questions of the applicant?
I do.
Okay, Vice Chair Cosgrove has a question. If you could just please state your name.
My name
For
is
the
Richard
record.
Cannon, represent the developer of the property. Welcome, new commissioners. We've spent a lot of time talking about this project, so glad to see you having a shot at it too.
Okay, thank you. Go
Yeah,
ahead.
it's a great project. It's a wonderful building. The mixed use is well done. And I think the sign program proposed is very classic and very nice. My question is specifically, do you have an idea what's going to go where? Could you walk us through that? If we bring the picture back up, could you say, this one's going to get the reverse channel, this one's going to get hand painted? Is that possible for you to walk us through that?
Of course.
Cool. Could we get the picture back up? Or the slide back up? That's a good one to start with.
So Commissioner Cosgrove, if you take a look at the building elevation as it stands right now, pretty much all the signs that as proposed are what we intend to install. So on the right-hand side, so on the northernmost portion of the property where Lucky Dog Gelato is, those actual signs have been, were submitted, approved and installed.
Yeah, those
So-
are up right now.
Those are
So,
up right
yeah,
now.
I was more the two to the left.
Right, so the other two are laser cut aluminum letters that are going to be painted black, powder coated and adhered to the wall. And they're going to look exactly like they look there. Then the one around the side is going to be painted black, hand painted onto the wall.
So let me just slow you down for a second. So where it has the actual address, 1010 Santiago,
Yes,
is that going to be illuminated?
Right.
Can I ask why you guys chose that, made that choice?
so I hired a graphic designer to come up with something to make the building look a little bit more interesting. That particular logo is the logo that we, from a marketing perspective, came up with for the building. The building's address is 1010 South El Camino Real. We've always liked that the property's name is 1010 Santiago. So there's a big blank wall there with nothing on it, and the building looks pretty bland and has looked since it was done. So we felt that was.
I think it looks
proportional.
great. My question is the choice not to illuminate it, since it is an address and it's a prominent sign identifying your building, but at night it'll be dark. When in fact you're being permitted to do the halo illumination. I'm just curious why you didn't choose to illuminate it.
It's a good question. I think we just don't want to overemphasize it. I think sometimes less is more. There is a fair amount of ambient light in the area because you do have some street lights and there is lighting on the wall. If you take a look at that elevation, if you look on either side of the door, there are black light fixtures. So even though we're not necessarily uplighting it specifically, I'm just conscious of the fact that I don't want to wash the walls too much with light. I don't think that anyone would have a problem seeing those signs from the street. I mean, the building's not dark at night.
Mm-hmm. Are you going to use the halo illumination on any of your signs?
Not at this point, no.
Okay.
Yeah, we can go on to the next ones, but these were the main ones. The Buona Forchetta is obviously a fairly long sign.
Mhm.
We felt that the signage was appropriate based on the height that is up there and the proportion. No one seems to have talked about that too much, but we designed that retail space so that we could have cut it up into multiple spaces if needed. And so if we had done that, you would have had two separate signs, that would have fitted within the 25 feet. It's a long sign. Those letters aren't all that big.
So, excuse me, I'm sorry, just to slow you down a little bit. So that sign, is that also going to be metal,
Yes,
just like the other two signs?
correct.
That-
Yes.
Okay. Gotcha. All right.
And then the next one around the side is going to be hand painted on. That's the Buona Forchetta logo.
Mm-hmm.
There is lighting in the vicinity, so there will be some lighting there. That's just going to be hand painted black paint on white integral stucco. The one to the left of the parking garage is actually something that was required by the city council. When we did the shared use parking agreement on this project, it was appealed from planning commission to the city council. We spent a bit of time talking about that. And one of the city council members specifically requested is that we put wayfinding signage on the building so that people knew that they would be able to park, the patrons to the restaurant would be able to park in the upper parking garage. So that signage on the left-hand side that says, office parking, gelato store parking and restaurant parking, that's the signage on the left.
I think that makes sense, because when I'm there, first of all, the gate's down and you're not open, so I get it. But it's not clear that that's public parking, so I think that will be very helpful.
To be clear, it's not public parking, it's parking available for the patrons. So, but yeah, that's what it will say.
Yeah,
And then the signage around the side on the next slide, on the left-hand side, there's a sign saying resident parking only. And then there's a small little mural, which is not shown on here, but that goes on the inside of the parking.
yeah, I think that'll look
Ordinances.
fantastic.
Yeah.
Yeah. Okay. And then, will you entertain me with the lights that I mentioned before? Your thoughts on that?
You mean uplighting those signs?
Nope. Moved
Oh,
on.
I apologize. So those were initially, we put those up as holiday decorations. We put lights up there and around the side. To my knowledge, there's no permit required for temporary lighting like that. Everyone's really liked them, and so we left them there. That steel pole is surprisingly secure. It doesn't move much in any wind. It's an electrical box channel. We can take them down. Everyone's just really liked them. The building looks pretty nice with them.
No, I have no problem with the presence. It's the implementation of that rod. Kids whiz by on their e-bikes, they grab that thing, it's down. I would just have you do it in a much more secure, professional way into the ground. Maybe not on the outside, maybe on the inside, something like, that just looks that does not look professional to me. It looks like it was just like you say, temporary, fine. But if you guys like it, great, make it permanent. Do it right. That would be my thoughts. I'm a little disappointed that you don't want to do the halo illumination, but I get it. So thanks for answering my questions.
Great, thank you.
Any other questions for the applicant? No? Thank you.
Appreciate it. Thank you.
Seeing no one else to potentially speak on this item, I'll close the public hearing and open it up to commissioner discussion.
David, did we have a letter to read from the
Oh,
public?
thank you.
Yes, I did receive an email.
Okay, so I'll reopen the public hearing. Thank you, Commissioner Campbell.
Thank you, Commissioner Crandall. Okay, so this is from Andrew Fletcher. Hi, I would have liked to attend the upcoming meeting, but unfortunately I won't be able to attend. My thoughts around the signage size being requested is too large considering the smaller signage already existing on the building exterior. Respectfully, Andrew. And that'll be the only public comment received.
Thank you. That was short and brief. With that, I will reclose the public hearing and open it up to commissioner discussion. Chair Pro Tem Camp.
Yeah, there's a lot to like about this sign program. I like the colors. I like the variety of signs that you're proposing. I actually agree with Commissioner Cosgrove that the Tivoli lights or whatever that are just kind of mounted on the corner there are a real eyesore. I think that especially at night, that's a glare field right there on that corner. I don't know who likes it, but if it's not permanently approved, I think that we should, I don't know if we can condition the removal
That's probably an
of
enforcement.
that thing. Or is that enforcement?
Are we talking about the cafe lights?
Yeah,
That's not part of the request, and I don't really see a nexus here.
Right.
okay.
If however, in the discussion from the commission, I as the head of code enforcement will make contact with the applicant, and then we will work with him to find a way to get
Perfect.
what he's looking for
Yeah,
and
perfect.
make sure that everything's according to code.
Okay, can we also look at the Santiago elevation? Again, please. The other one, is this? On the, I'm sorry, the side. Elevation. Okay, so the one that's exceeding. The maximum is the Buona Porchetta. Right, specifically, or is it the combination of all the signs?
And the sign you see here is causing it to exceed the 25. Correct.
Okay, so it's the one above the arched opening there in the corner. That's
Correct.
okay.
The one on the far right. Uh-huh.
Okay, so can we also look at the corner photo of the building that identifies, okay, that one? So if you're driving up the street, you're gonna see both of those signs at the same time. And it seems to me that the sign above the triple opening on El Camino Real is the one that you're gonna be drawn to mostly. So, you know, I think it's okay to have a sign on the side, but that particular sign on the side elevation and the size of it is disproportionate, I think, to that wall there on that elevation. It's just too big. It doesn't need, for one thing, you're gonna see a really nice large sign above the triple arch. And that one, to me, it's squeezed in. There's not enough wall space around it. I think, you know, I could go along with a circular sign like that, because I guess it works with the radius on that opening, but it's, I just think it's too big. It's disproportionate on that corner. And I don't see that there's a real need. It'd be one thing if you couldn't see that sign in the front, but you can see both of them as you're driving down the street. So again, I'm not opposed to having it, but it's not proportionate to that wall. I don't think it works.
Yeah, can I interrupt on that? That's a great point. And we had that discussion in design review subcommittee. And it looks to me like, that's why I asked, were these things changed from the prior submittal? Because Commissioner Crandall really honed in on that. If you look at sheet 15, as opposed to the graphic that they've been showing, it looks a little smaller.
No.
Still too big, I
It's
think,
still-
on that.
yeah,
Well,
no.
I think what worked with it is, it's not a solid sign. In other words, that circle you see there is just the letters, and then there's a small logo in the middle. So it doesn't read like a full sign. Because the back is building color. Background is the building color because it's painted on. And I think page 15 does show that it was reduced, and we did hone in on it. And when you look at that wall without it, it does look pretty plain. That adds a little interest, and it does relate to the arches below. And so at design review, we gave him the recommendation to just reduce the size down a little bit. And at that meeting, we were comfortable with it.
My impression is that the image on 15 is smaller than it was before, what we saw at DRSC, but
And that's part of the master sign program. That's the actual program right there.
I can see the benefit of allowing it, especially if you have a multi-tenant in the future. So that's a benefit to the property owner and to the citizens. Maybe it's just a size concern.
Yeah, but if we allow the increase in square footage, then that runs with the building, right? So if this changes, then staff has the discretion to approve a different sign that still exceeds the allowable square footage. So that's a concern. Because I think, you know, you guys may not agree with me, but I think it's too big proportionally. I actually don't mind that. The wall area on the above those arched openings, especially since we've got that balcony with the open guardrail. up above it.
David,
Yeah,
could,
I just don't see the
Yeah.
need for an increase.
David, could you weigh in
Center.
uh, Chair Pro Tem Camp's comment about the size of that particular sign?
Yes, that.
And or recommend a potential pathway solution that we could approve tonight?
I will, yes, Commissioner. I will say that at the design review subcommittee, as mentioned already, this sign was brought up by staff, and actually there was a recommendation to reduce the size that was initially proposed to give more cushion at the top of the sign and at the bottom of the sign. DRC agreed, and we made that request at the meeting, and the applicant did reduce it. Staff did feel it was sufficient. One of the elements that comes with Spanish colonial revival architecture is the stucco mass, and we do have a design guideline that talks about stucco mass being the dominant feature. I think we still achieve that on that facade. It still remains dominant. The stucco still remains a dominant feature on the south-facing facade. So a potential solution is maybe going from a round sign to maybe something that's more horizontal, and that can probably alleviate some visual noise at the top and bottom instead of keeping it circular. That'll be my potential solution, going from a round sign to a more horizontally oriented sign.
Okay, thank you.
I want to ask him a follow-up, if that's
Okay, yeah, please.
So David, is the location of the signs up to the building owner or the applicant? Or is this sign program specifying the locations?
The sign program is specifying the location. So the signs that we see on the elevations that we see on the elevations are the locations that any future tenant would be subject to or limited
Okay.
to.
Just wondering if, as an option, would it make sense to everybody here if the sign were centered between those two arches? There's a little bit more space there, and in the event that it's a future tenant and that they bifurcate the space, it would allow for them to have their own and identification there. And I'm wondering too, is that drainage that's coming through the wall there from,
Scuppers.
what's that?
Those are scuppers for the balcony.
Yeah, and because I'm just wondering is when over time as it drains, will it stain the stucco and kind of deface the sign? And if it were centered, it might avoid that. But those are just some thoughts for people to think about.
Thank you.
Can I ask one more question? So how much does the how much are we exceeding the square footage? Is it like 20%?
Close to, so the limit is 25 square feet, and they're proposing 54. So I'd say it's pretty much 30 square feet. They're exceeding,
30?
yeah, if we round up, yeah, 30 square feet, more than what is allowed.
30 square feet over.
Oh, okay, so it's over 100%
Yeah,
increase.
yeah, they're proposing 54,
And
they're like
25 is
25.
what's allowed.
Okay, so.
Yeah.
It's excessive.
but it's within our purview to,
I
we
understand.
can approve.
That's just my opinion.
Chair Grant, Commissioner
And,
Grant.
and it is, that's typically when you get two sides to a building on two different streets. They aren't fighting each other. They're still on the main wall, they comply. And putting it on the side street, we looked at this a long time and played with moving that round one around, and it looks pretty darn good here, particularly with the painted sign. And at the end of the design review subcommittee meeting, we were comfortable with it. And that's where we could spend the most time. We spent a good hour or so going this thing.
You say that, but in
Yeah.
fairness, we didn't get to see the revision version. We just said shrink it.
Well, it reduced.
It's bigger.
And with the quality of this building and so forth, I don't think the signage is hurting the architecture. Obviously, Steve and I have a different aesthetic outlook at it, and that's fine. That's why we try not to design the dais at the commission level. Because it's hard to get everybody to feel the same way, but I will say that after reviewing it and looking at it, and this applicant has done to make this building what it is today, I can support what we're seeing with the application.
Thank you.
Chairman, again,
Yes,
looking at this and also appreciating the design review. It is on the corner, the rounded corner. I'm comfortable with the location. It's a beautiful building, and I think the signs will benefit the building, the design. I can go through each one of these A, B, C, D. I mean, it is the size. I think it's to scale of the building. The design looks like it will be very professional, and the large one that goes over the 3 arched windows, I think will look very nice. And I'm very comfortable with the one on the corner because it is on the corner. It is the joining of the 2 streets. So you're going to see it coming down the street, and you're going to see it as you turn. So I'm very comfortable with that. It looks very nice. The building itself is beautiful.
thank you very much.
I did have one quick question.
Sure.
If they did decide to illuminate the signs later, do they just go through code, or would they have to come back through planning?
It'd be administrative.
Oh, I'm looking at Adam,
You're-
and I should be
I
talking
just
to
want to,
David.
I want to confirm your question. You're talking about they want to add lights?
Yes, if they decided that it was too dark and they wanted to, or another tenant comes in and wants to put a type of a halo light or an uplight, does it have to come back through us? Would it benefit them
Sign, yeah.
to do it now?
It would benefit them to do it now. There are some very, very minor modifications that can be made to previously approved applications that can be done so administratively through a city planner determination. Adding lighting onto a building that has gone through a master sign program review is probably not something I'm going to be entirely comfortable approving administratively. But there is a process. It could be a change that could be reviewed by the zoning administrator rather than the planning commission. It depends on what they're proposing. But the master sign program does cover the signs and the way that they are lit. So even an external light whose purpose is to illuminate a painted sign would be something that this master sign program should cover.
Okay, and I will,
Any other
in
questions?
my questions.
Commissioner
are you-
Davies?
So as far as I understand, this is to approve illuminated sign, correct?
That is
Correct.
Okay, so in 2 years, if he wants to illuminate a non-illuminated sign, it's still approved because that's what's being approved today. Is that correct?
what's being approved today, or what is being
Yeah.
reviewed for
Yes.
potential approval today is the master sign program's allowances as proposed. So if there is a sign, the 1010 Santiago project description sign, we'll call it. If that one is not shown as illuminated in the master sign program, then that would be an addition. That would not be something that's covered. However, if all of the other signs indicate that they could have a number of styles and they could be internally illuminated or externally illuminated, then those kinds of changes could be reviewed at a staff level administratively in the future.
Okay, one more thought is I get why a restaurant would want to have this type of signage, the big oval that's out in front of those 3 arches. But just planning or future down the line, what if a restaurant vacates that and it becomes a State Farm building? Do we want the State Farm building? If say a restaurant or the type of business vacates that property, do we want that applicant to reapply for the new type of tenant? Because I get why the exception is being requested for a restaurant, but I'm new to the game, but I'm just throwing it out there. See what you guys think about that.
What I would say, correct me if I'm wrong, is that what we're approving, they could change it to, if we're approving this size and location and scale of signage. And as tenants change over the years, it's possible that something different can come in, but it's already approved by us.
So is there something to consider that if a restaurant style thing goes out of there and it becomes State Farm, do you want State Farm on?
You,
that one?
you need to take that
Well,
into
we-
consideration of your decision. And all of
I'll
us
have
do.
to say one thing. We can't say what the sign says.
True.
It has no
No bearing.
bearing on our decision. It's just the space and size, regardless of who the tenant is. We got to be real careful about not getting
That
into the
First Amendment.
content.
Right. Okay.
Right. Okay, any other discussion points? I did see the applicant indicated he might want to speak again. Do you want to? And if so, I'll reopen the public hearing.
Hello, I'm Ryan.
Oh, okay, Ryan, are you the person who wrote a letter?
No, I'm part of the applicant team.
Okay.
Ryan, this is Nick here. We're good. Did you want to open public comment again, sir?
I did open it. Yes, you can comment.
I just, for Adam's and my benefit, I just wanted to clarify something. I think you did a really good job, and I'm never going to speak against Adam about how I explain certain things. But what we doing tonight is, this is a discretionary hearing to lay out the criteria for which staff can administratively approve things. So Commissioner Davis, when you mentioned a little bit earlier, the lighting and what have you, yes, we can come and install that later on, but the applicant can't do it on our own unilaterally. We would need to come back and work with staff, and staff would need to determine, in their opinion, whether that was consistent with the intent and the guidelines laid out in the signage program. I just thought it was important to lay that out, because we can't just unilaterally out there go and change it to a State Farm sign or anything like that. The other thing is also, think it's important that we seem to have gotten ourselves comfortable with the sign on the corner, but I just feel that graphic up there really badly shows the size of the sign, because that graphic has a big yellow circle on it that was put on by staff to highlight where the area was. Was if you actually look at the sign program itself, it's black and it's a lot smaller than appears in that graphic. And I think the other thing that's important to mention is, when you're looking at signs and things like that, you got to look at proportions in the area from which someone's looking at something. So if you're driving down the road and you're looking at a sign on a building that is maybe 50 feet away, if you squash a sign, like if it's a logo or something like that, and it's got little intricate details in it, sometimes it makes it to a point where it's no longer worth having that sign anymore, because those details and the words on the sign are just no longer legible to the human eye. So I just, at least, was hoping you'd consider that, at least, as you look at this. That's all I wanted to say. Thank you.
Thank you again. I'll reclose the public hearing, which seems to be my new mantra. From a discussion point of view, I'd like to give my thoughts. I think the applicant's done a exceptional job with the building primarily, and with the sign program as well. And I think the sign program, we beat it up in Design Review Subcommittee. And I think it's appropriate in scale and design for the building. And I'm fully supportive of this master sign program as designed. And with that, I'm open to any motions or further discussion. Seeing none, I'll make a motion.
Yeah, I'm just looking.
Would you like to?
I would be happy to make the motion and just fumbling through the pages here.
One more page. over. Right there.
Okay, did you find it?
Not yet, I'm looking for the address.
Attachment 1.
Oh, there we go. I would like to make a motion to approve this project, discretionary sign permit 21-28. Pardon me, glasses, I believe that's a 9. 1010 San Diego Master Sign Program. And do I need to say more before I get a second?
Does she need to say more? Or do we need to
I
cover
don't-
CEQA stuff?
Yes,
Okay.
just for clarification. Staff recommends two things. First is that a determination about CEQA be made. And the second is the adoption or approval of a resolution.
Okay.
Technically, the CEQA finding needs to be made before.
What page is the CEQA on? 6, thank
It
you.
would be at the last page of the staff report, there's
Page 6.
All right.
staff recommendations.
Sorry, I wasn't prepared. I was taking notes. Okay. Let's start from the beginning. I would like to make a motion to approve the discretionary sign permit 21-289 1010 Santiago Master Sign Program. And the request is to consider the master sign program for mixed-use development located on 1010 South El Camino Real and to allow more than 25 feet of the sign area for business within the architectural overlay.
Second.
And what?
Should
do
do
we-
the sequel.
We need the CEQA.
Recommendation by staff to determine the project is categorically exempt from the requirements of CEQA pursuant to CEQA guidelines, section 15301, class 1 existing facilities, and 15311, class 11 accessory structures, and adopt a resolution of PC 22015 approving discretionary sign permit, which is 21289 at 1010 Santiago Master Sign Program.
Now we will do a second.
Motion by Commissioner Prescott, second by Commissioner Crandall. We'll take a roll call vote. Commissioner Prescott,
Aye.
Commissioner Davis.
Aye.
Commissioner Crandall,
Aye.
Vice Chair Cosgrove,
Aye.
Chair Pro Tem Camp,
Nay.
and I am an aye. So the item passes 5-1 with Commissioner McCacken absent. Congratulations.
I hope all our mixed use projects look so good.
Yeah. no, it's
Yes,
awesome.
yeah, your building is beautiful. New business, we have no new business. Old business, we have no old business. Reports of commissioners and staff. Does anybody have anything for staff? Do we know if we have a planning commission on the 17th? Do we have anything for the agenda?
For 17th, I believe not. Yeah, we don't have any public hearings because we haven't, there haven't been any notices. And we don't have any, we don't have a study session. No, I'm sorry, we do have, do we have that study session or is that the joint one that we were discussing? Okay. Yeah, we don't have anything on the TFA. I would, in case there is a new business item or something that might be added that doesn't require a public hearing, I'd like to keep it available.
So-
But most likely there will not be.
So when we adjourn, we'll adjourn till the 17th.
Yeah, that would be our preference. There are there's a joint council, commission, committee. Basically anybody appointed, meeting on the 30th. And I believe that you all have been contacted about a potential joint council commission study session on the 31st. I would be okay if the commission would like to adjourn to the August 30th joint meeting. I can find, we can find the language for that. Right, are we good? Yeah, we can find the language for that. And should something come up, we can always notice a special meeting in between. But since we're considering potentially 2 more meetings this month, yeah, it might be nice to lay off the 17th.
Do you have time and place on those 2 meetings for everyone's benefit?
I don't have a time and a place on the 31st.
Okay.
But what all we would need to do at this meeting is adjourn to the meeting on the 30th, and if you give me 1 second, I will.
Isn't that at the
It's
golf
called
course?
Joint council / commission /
Yeah,
committee.
it's going to be, it's going to be at the, let me.
It's at the golf course, isn't it?
It's at
Yeah.
the golf, municipal
Exactly
golf course.
It says Wedgewood. Is that the room?
Ironwood or Wedgewood. Yeah, Wedgewood.
Mhm.
At 5.
Hold on, I want to make sure that we do this.
6, sorry.
6.
You hold it out here. It's a 6.
Okay. Okay, I will, I'll read the official time and location. And you can just incorporate that into any motion for adjournment. All right. The joint council commission committee meeting is set for August 30th, 2022 at 6 p.m. at Wedgewood at the San Clemente Municipal Golf Course.
Okay, thank you.
I'll make a motion, we adjourn as
Before you
Read
do,
by-
before you do that, can I ask one question? I don't know if I don't think we need to agendize this, but we always seem to have some confusion about what to read specifically relative to motions of approval. Can you guys, and maybe you're already doing it, but you've got recommendation, and it's been our practice to read the whole intro to the resolution. I don't know if that's necessary or not, or can we just have it in the staff report as a recommendation of proposed, language, so that we all collectively know where to look for it and what to
Yes,
move.
I'm glad you mentioned that. Sarah and I were discussing this tonight because this is, I've seen this a number of times. What I would like to do is add staff's recommendation to the agendas. So you can just go back to the agenda item and there's item 1 and item 2. Trying to find it in the staff report seems to be a little hit or miss.
Challenging, yeah.
So if
sometimes.
it's okay, putting it in the agenda, great. If there's additional ways that you would like us to clarify what those recommendations are, I'm more than happy to look into that. I wouldn't, I don't know that I want to put it more towards the front, but maybe as an executive summary kind of for the, on the staff report. So it's on page 1, so you know kind of
Okay.
where it's leading. I'd be happy to look into doing that as well.
That'd be great. And I don't need an answer right now, but I'm looking at this recommendation of this last item. It had, item 1 was a sequel recommendation. Item 2 was a succinct recommendation relative to the sign program, as opposed to the 6 or 7 line intro at the top of the resolution. So if we don't have to do the full resolution heading, let's keep it succinct, but I'll let you guys figure that out and tell us what to do.
Yeah, we will provide what needs to be read into the record.
Perfect. That's
Chairman,
this monkey see, monkey do needs.
Chairman McCann, thank you for that.
Sure. With that, I'm open to a motion from Commissioner Crandall to get us out of here.
Okay, I move we adjourn to the August 30th, 2022 Joint Council Commission meeting at Wedgewood Golf Course Clubhouse at 6 p.m.
Second,
Motion by Commissioner Crandall, second by Vice Chair Cosgrove. Commissioner Prescott,
Aye.
Commissioner Davis.
Aye.
Commissioner Crandall,
Aye.
Vice Chair Cosgrove.
aye.
Chair Pro Tem Camp,
Aye.
and I am an aye. Thank you very much.